Okay, magpunta na tayo sa fourth major topic natin sa civil law, obligations and contracts under Articles 1156 up to 1304 of the Civil Code. Article 1156, an obligation is a juridical necessity to give, to do, or not to do. So, meron tayong civil and natural obligation. And civil obligation, ito yung obligations which give to the creditor or obligee a right under the law to enforce their performance in courts of justice. Yun ang civil obligation. Natural obligation, not being based on positive law but on equity and natural law, do not grant a right of action to enforce their performance, although in case of voluntary fulfillment by the debtor, the latter may not recover what has been delivered or rendered by reason thereof. The precept is based on do good and avoid evil. Yun yung natural obligation. Yan. Okay, asan na ba ako? Ayan. Okay, ano ba yung 4 essential requisites of an obligation? Number 1, there is a passive subject o yung debtor or obligor. The person who is bound to the fulfillment of the obligation, siya yung dapat na mag-deliver o magbayad. Number 2, an active subject. Ito yung creditor or obligee. Bakit active subject? Kasi ito yung gustong-gustong mabayaran siya. The person who is entitled to demand the fulfillment of the obligation. Number 3 is the object or prestation. Ito yung subject matter of the obligation. The conduct required to be observed by the debtor. Ayan, It may consist in giving, doing, or not doing. Number 4 are juridical or legal tie. Ito yung efficient cause. That which binds or connects the parties to the obligation. Ayan. The tie in an obligation can easily be determined by knowing the source of obligation. Ayan. Sabi pa, obligations daw can be oral, in writing, partly oral, and partly in writing. So, ano naman yung kinds of obligation according to subject matter? According to subject matter. Ito naman yung real obligation. Ito yung obligation to give. And personal obligation, which is obligation to do or not to do. So, under real obligation, the subject matter is a thing which the obligor must deliver to obligee. For example, X, the seller, binds himself to deliver a piano to Y. So, the seller has the obligation to deliver to the obligee. Number 2, yung second kind of obligation according to subject matter, yung personal obligation. Tumatawag si Aso. Ito yung obligation to do or not to do. The subject matter is an act to be done or not to be done. Letter A, positive or personal obligation. This is under personal obligation. Positive personal obligation. This is the obligation to do or not to render service. And letter B, under personal obligation, it is the negative personal obligation. This is the obligation not to do. So for example, X obliges himself not to build a fence on a certain portion of his lot in favor of Y, who is entitled to a right of way over said lot. So, yun yung positive personal obligation and negative personal obligation under personal obligation. So, according to subject matter, the real obligation to give, and personal obligation to do or not to do. So, under Article 1167, sources of obligation, ano ba yung mga iba't ibang sources ng obligation? Number 1, law. Number 2, contracts. Number 3, quasi-contracts. Number 4, crimes or acts or omissions punished by law. And number 5, quasi-delicts. So, ano ba muna? Ano ba muna yung law? Siyempre, when they are imposed by the law itself. For example, obligation to pay taxes, support one's family. It is imposed by law. Sa contracts naman, when they arise from the stipulation of the parties, nagkaroon ng meeting of the minds yung dalawang partido. So for example, obligation to repay a loan or indebtedness by virtue of an agreement. Number 3, quasi-contracts, when they arise from lawful, voluntary, and unilateral acts. Ayun, nawala ako. Quasi-contracts, when they arise from lawful, voluntary, and unilateral acts which are enforceable to the end that no one shall be unjustly enriched or benefited at the expense of another. Example ng quasi-contracts, the obligation to return money paid by mistake or which is not due. That is an example of a quasi-contract. Number 4, crimes or acts or omissions punished by law. So when they arise from civil liability, di ba pag may krimen, merong kaakibat lagi na civil liability. So crimes or acts or omissions punished by law when they arise from civil liability, which is the consequence of a criminal offense. Example, the obligation of a thief to return a stolen car. Duty of a killer to indemnify the heirs of his victim. Number 5 na source ng obligation, yung quasi-delicts or torts. Torts or quasi-delicts, when they arise from damage caused to another through an act or omission. When they arise from damage caused to another through an act or omission, there being fault or negligence but no contractual relation exists between the parties. So an example of this, the obligation of the head of a family that lives in a building or a part thereof to answer for damages caused by things thrown or falling from the same. The obligation of the possessor of an animal to pay for the damage which it may have caused. So yan ang obligations arising from quasi-delicts or torts. Okay, so yun ang 5 sources of obligations. Once again, law. Number 2, contracts. Number 3, quasi-contracts. Number 4, crimes or acts or omissions punished by law. And number 5, quasi-delicts or torts. Sabi nga sa Article 1158 of the Civil Code, obligations derived from law are not presumed period. So ulitin natin, obligations derived from law are not presumed. Only those expressly determined in this code or in special laws are demandable and shall be regulated by the precepts of the law which establishes them, and as to what has not been foreseen by the provisions of this book. So yun ang ating mga obligations. Article 1159, obligations arising from contracts have the force and effect of law between the contracting parties and should be complied in good faith. So ano ba muna yung contracts? Contracts is a meeting of minds between two persons whereby one binds himself with respect to the other to give something or to render some service. Okay, so dahil a person binds himself to give something or to render his service, it has the full force and effect of law. Maliban na lang kung illegal yung provisions ng contract. And the parties should comply the contract in good faith. So ano ba ibig sabihin ng good faith? Good faith means compliance or performance in accordance with the stipulations or terms of the contract or agreement. Sincerity and honesty must be observed to prevent one party from taking unfair advantage over the other. Article 110, obligations derived from quasi-contracts shall be subject to the provisions of Chapter 1, Title 17 of this book. And so ano ba yung kinds of quasi-contracts? Kasi naano natin yan kanina. Nadaanan natin siya kanina, yung quasi-contracts na yan. So, ito yung dalawa, yung kinds of quasi-contracts, negotiorum gestio and solutio in debiti. So, negotiorum gestio, voluntary management of the property or affairs without the knowledge or consent of the latter. So, the gestor should manage with due diligence, no? Yung gestor, ito yung so negotiorum gestio is an instance wherein merong nagpresenta, ikaw yung may-ari, wala kang kamuamang pero nagmalasakit siya doon sa property or affairs pero wala kang alam. Ang solutio in debiti naman, juridical relation which is created when something is received when there is no right to demand it and it was unduly delivered through mistake. Ang requisites ng solutio in debiti are, letter A, there is no right to receive the thing delivered. Kunwari, hindi naman sa akin dineliver yung Lazada, paid na siya pero hindi naman akin yon. Hindi ko naman in-order yon. Okay, there is no right. So, kailangan ko siya isoli. And letter B, the thing was delivered through mistake. Ayun na nga, through mistake. Wala akong karapatang tanggapin yon. And at the same time, the thing was delivered through mistake. So, under Article 1161, civil obligation. Kasi obligation pa rin yung pinag-uusapan natin. Civil obligation arising from criminal offense shall be governed by the penal laws subject to the provisions of Article 2177 and of the pertinent provisions of Chapter 2, Preliminary Title, on Human Relations and of Title 18 of this book, which is the Civil Code, regulating damages. Yan. Source, ang scope of civil liability, ito. The extent of the civil liability arising from crimes is governed by the revised Penal Code and Civil Code. Kasi arising from crimes When it comes to number 1, restitution, number 2, reparation for the damage caused, and number 3, indemnification or consequential damages. Okay, so himayin natin ng konti yung pagkakaiba ng crime. Sabi natin kanina, crime is a source of obligation. At saka yung quasi-delict, ang pangit nitong sulat ko talaga. So, ang crime, criminal or malicious intent or criminal negligence. Yan, crime yan. Sa quasi-delict, only negligence. Walang criminal or malicious intent. As to, sa krimen, the purpose is punishment. Yung obligation niya sa krimen, kailangan siyang i-punish. Sa quasi-delict naman, indemnification of the offended party. Sa crime, it affects public interest. Kaya nga people of the Philippines versus, ganun ang crime. Quasi-delict naman affects private interest. Merong two liabilities generally ang crime, which is the criminal and the civil liability. Yun nga, criminal, kailangan siyang parusahan, ikulong, and the civil liability, daños perjuicios. Yan. Sa quasi-delict, only civil liability. Walang criminal liability sa quasi-delict. Ayan. Number 5, cannot be compromised by the parties themselves. Yung quasi-delict can be compromised ng dalawang partido. Number 6, guilt of the accused must be proven beyond reasonable doubt pag crime. Pero sa quasi-delict, fault or negligence need only be proved by preponderance. Okay, so magbasa-basa tayo ng ibang nakasulat dito. In relation na to deposit, ito pala. Basahin na rin natin. Deposit. Mamaya na. Sa credit transactions. Okay, mamaya na yung deposit na yan. Okay, tapos na tayo sa obligations. Magtungo naman tayo sa contracts. Ayan. It is the fourth major topic, di ba? Contracts naman. So, under the Civil Code defines a contract as a meeting of minds between two persons whereby one binds himself with respect to the other to give something or to render some service. So may three elements dyan must be present. Consent, dapat may consent, merong object, and merong cause. So ano yung tortious inference? Tortious inference under Article 1314. Ang requisites nito, number 1, the existence of a valid contract. Number 2, the third person must be aware of the existence of the contract. And number 3, the interference of the third person must be without legal justification or excuse. Yun ang tortious inference. Okay, so ulitin natin ha, yung tortious inference ha, merong valid contract. Tapos may ibang tao na hindi naman siya kasali sa contract pero aware siya na valid yung contract. Tapos ikatatlo, nakialam siya nang wala namang legal justification. Ang action daw na nararapat doon in court ay action Pollyanna. It is an action to rescind a contract entered in fraud of creditor. So action Pollyanna, ang kailangan kasi yung ginawa dito sa tortious inference, nag-initiate yung stranger o third person against parties to a contract. So requisites para makapag-avail tayo ng action Pollyanna that the third person who received the property conveyed if by onerous title has been an accomplice in the fraud, the plaintiff asking his prior credit. Yan meron palang ganito, no? Tortious tortious interference. Okay, dahil nasa contracts tayo, ano ba yung pinaka-popular na contract? Ito yung contract of sale. Okay. By the contract of sale under 1458, by the contract of sale, one of the contracting parties obligates himself to transfer the ownership of and to deliver a determinate thing and the other to pay therefore a price certain in money or its equivalent. A contract of sale may be absolute or conditional. So transfer of ownership ang concept nitong contract of sale dahil kahit hindi indicated, it is the fundamental aim of the contract of sale. For example, namili ako sigarilyo. The fundamental aim is i-transfer niya sa akin yung ownership ng sigarilyo. So under the civil code, if at the time the contract of sale is perfected, the thing which is the object of the contract has been entirely lost, the contract shall be without any effect. Wala nang epekto. Bibili ako sigarilyo. Nawala naman yung sigarilyong ibibigay niya sa akin. So wala kaming kontrata. In contract of sale, the vendor loses ownership over the property and cannot recover it unless and until the contract is resolved or rescinded. Yun ang contract of sale. The vendor loses ownership over the property and cannot recover it unless and until the contract is resolved or rescinded. Ang kaibahan niya naman sa contract to sell. Contract to sell, title is retained by the vendor until full payment of the price. Mas madaling intindihin siguro to kung yung ORCR nakapangalan pa doon sa seller hanggat hindi nagpo-full payment yung buyer. Ayan. So yun ang kaibahan in contract of sale. Vendor loses ownership. In contract to sell, title is retained until the full payment of the price. Yan. So ano naman yung Sale of Goods Act? Ito yung mga iba't ibang remedyo. Iba-ibang mga remedies for breach of contract. Contract of sale. Number 1, ano to? Suit for the price. Yan. Under Sale of Goods Act. Suit for the price. Number 2, recovery of losses in case of resale of goods while exercising the right of lien or stoppage of goods in transitu. And number 3, damages for non-acceptance. Yan yung mga remedies for breach of contract under Sale of Goods Act. Yung number 1, ulitin natin. Suit for the price, bayaran mo yung halaga. Number 2, recovery of losses in case of resale of goods while exercising the right of lien or stoppage of goods in transit. Ako yung seller, pinatigil ko yung goods in transit kasi nalaman ko wala ka naman palang pambayad. O edi ibebenta ko na lang siya sa iba. So kailangan ko ng recovery of losses. And number 3, damages for non-acceptance. Di mo tinanggap o di na-damage yung goods. Okay. Yan yung Sale of Goods Act. Ano naman ang recto law? Ito naman yung Act number 4122. It refers to sale of personal property on an installment basis. Yan yung recto law. Sale of personal property on an installment basis. 3 remedies of buyer. Number 1, specific performance. Number 2, rescission. Number 3, foreclosure if one has been constituted. The remedies are alternative and not cumulative. The exercise of one would preclude the other remedies. So kung nakapag-specific performance ka na, hindi mo na pwedeng gamitin yung rescission and foreclosure dun sa particular na contract na yon. A stipulation that the installments or rents paid shall not be returned to the vendee or lessee shall be valid insofar as the same may not be unconscionable under the circumstances. Ulitin natin ang sinasabi sa recto law. A stipulation that the installments or rents paid shall not be returned to the vendee or lessee shall be valid insofar as the same may not be unconscionable under the circumstances. Magtungo naman tayo sa Maseda Law. Ay yung mga acts na inaral natin. A Sale of Goods Act, merong recto law. Ito naman, Maseda Law. Maseda Law refers to sale of real property on an installment basis. Yung recto law, personal property. Maseda Law is for the sale of real property on an installment basis. This is applicable to buyers who have paid at least 2 years of installments and buyers who have paid less than 2 years of installments. So kapag yung buyer nakapagbayad na siya for at least 2 years of installments, the buyer shall have the right to pay without additional interest. Meron din siyang right to refund the cash surrender value of the payments on the property if contract is canceled. So kasama doon yung down payment, deposit, or options on the contract. Kapag naman the buyer have paid less than 2 years of installments, the seller must provide the buyer with a grace period of at least 60 days from the date the installment become due. Ganda rin itong Maseda Law na ito. So under the Section 6 of the Maseda Law, the buyer has the right to pay in advance the installments or the remaining balance of the purchased property in full at any time without interest. Yan. Napakaganda naman. Ulitin natin. Ang Sale of Goods Act, remedies for breach of contract of sales. Recto law naman. Ayan para siya sa mga sale of personal property on an installment basis. Maseda Law naman refers to sale of real property on an installment basis. Yung kaibahan nilang tatlo. Okay, magtungo naman tayo sa extinguishment of sale under Article 1600. Sales are extinguished by the same causes as all other obligations. Number 1, payment or performance of obligation, loss of the thing, condonation or remission of debt, confusion or merger of rights, compensation, novation. Yan. Na-extinguish yung sale doon. And number 2, conventional redemption. Yan. Okay. Under Article 1601, okay, itong conventional redemption shall take place when the vendor reserves the right to repurchase the thing sold with the obligation to comply with provisions of Article 1616 and other stipulations which may have agreed upon. So, if no stipulation, within 4 years, ang sabi ng Article 1616 of the Civil Code. If there is stipulation, it shall not exceed 10 years. Otherwise, the stipulation is void. So, yan yung sinasabi. So, na-discuss natin payment or performance, yung mga ganyan. Conventional redemption, dinefine natin, ikalawa. At yung ikatatlo na topic natin na extinguish, na may extinguish yung sale is the legal redemption under Article 1619. So, legal redemption is the right to be subrogated upon the same terms and conditions stipulated in the contract in the place of one who acquires a thing by purchase or darshan in payment or by any other transaction whereby ownership is transmitted by onerous title. So kanina pa natin sinasabi yung onerous title. Ibig sabihin ng onerous title, title to the property acquired by giving valuable consideration. That is onerous title. Darshan in payment is discharging a debt by the debtors, giving to the creditor with the latter's consent something in full satisfaction of the obligation, but a character different from the originally called for by the obligation. So, kunwari, may obligasyon ako na may obligasyon ako sa kanya, hindi ko nagawa, so utang ko yon. Mag-deliver ng upuan, nag-deliver na lang ako ng lamesa, pumayag siya, lamesa na lang, may stock ako ng lamesa. Yun ang darshan in payment. Okay, so ulitin natin. Tatlong modes of extinguishment of sale. Number 1, payment or performance of obligation, loss of the thing, condonation or remission of debt, confusion or merger of rights, compensation, evasion. Number 2, conventional redemption. And number 3, legal redemption. Okay, so ayan na. Contract of sale. Okay, ano ba yung novation na yan? Ano ba kasi yung nabanggit natin yung novation eh? Novation is the extinguishment of an obligation by substitution or change of the obligation by a subsequent one which extinguish or modifies the first either by, number 1, by changing the object or principal conditions, or either by substituting the person of the debtor, or either by subrogating a third person in the rights of the creditor. Itong subrogating na to, ginagamit lamang ang subrogating na term sa creditor. It is the transfer of all the rights of the creditor to a third person who substitutes him in all his rights. Okay, para bagang in a scenario wherein sinanla ko yung bahay ko kay creditor A, tapos yung pagkakasanla ko sa kanya, yung value nun, binayaran ni creditor B. So hindi na ako kay creditor A magbabayad nung utang ko, kundi kay creditor B na. Siya na yung may hawak sa kanya na ako nagsanla ng bahay. Kinuha niya na kay A. Yun ang subrogation. So may dalawang uri ng subrogation, legal subrogation and conventional subrogation. Number 1, legal subrogation takes place by operation of law. An example of this, yung insurance payouts. And number 2, conventional subrogation is that which take place by agreement of the parties. Ito yung sinasabi ko. Extinguishes the obligation and gives rise to a new one. Okay, extinguishment pa rin ng obligation yung pinag-uusapan natin. Ano naman yung pacto de retro sale? Parang impacto, no? Pacto de retro sale. Para magandang pangmura yan sa tao na pag-visit ka. Pacto de retro sale. Nonsense. Okay. Pacto de retro sale is a sale with pacto de retro transfers. Yan. Ay, ulitin natin ang pangit na sulat ko eh. Hindi mo alam kung nasaan yung kama, yung period. Okay. A sale with pacto de retro transfers the legal title to the vendee a retro. The essence is that the title and ownership of the property sold are immediately vested in the vendee a retro, subject to the resolutory condition of repurchase by a vendor a retro to repurchase a property within the period agreed upon by them, or in the absence thereof, as provided by law, vests upon the vendee a retro absolute title and ownership over the property sold by operation of law. The failure of the vendee a retro to consolidate his title under Article 1607 of the new Civil Code does not impair such title and ownership because the method prescribed thereunder is merely for the purpose of registering and consolidating titles to the property. Yan yung sinabi, yan yung pinakahulugan ng ating Korte Suprema sa kasong Kadungog versus Yap, GR number 161223. Pacto de retro. Hirap intindihin, ano? Equitable mortgage. Ano naman ito? Equitable mortgage. An equitable mortgage has been defined as one which, sandali, iba ng topic to, mortgage na. Sige, yan na natin. Mortgage. Okay, ano na rin natin? This is about equitable mortgage na pero basahin na rin natin ngayon. Kasi nakasulat na siya. So, equitable mortgage. Ayan, okay. An equitable mortgage has been defined as one which, although lacking in some formality or form or words or other requisites demanded by a statute, nevertheless reveals the intention of the parties to charge real property as security for a debt, there being no impossibility nor anything contrary to law in this intent. Yun yung definition ng ating Korte Suprema sa equitable mortgage. So, hindi man siya, lacking man siya in some formality, nevertheless, pinakita niya naman yung tunay niyang intention. Tunay na intention ng partido, ng dalawang partidong nag-usap, which is to charge the real property as security for a debt. Yan, okay. Ano naman ang assignment of credit? Assignment of credit is an agreement by virtue of which the owner of a credit known as the assigner by legal cause such as sale, dation in payment, exchange, or donation, and without the need of consent of the debtor, transfers his credit and its accessory rights to another, known as assignee, who acquires the power to enforce it to the same extent as the assigner could have enforced it against the debtor. Ayan. Assignment of credit. Similar siya sa concept ng subrogation, no? Nag-uusapan natin kanina. Okay, pag-usapan naman natin ang statute of frauds. Yan. Ang sabi niya, statute of frauds is applicable only to executory contracts. Ito yung mga kontrata na kung hindi mo susundin, they would amount into unjust enrichment. So, doon lamang nag-apply yung statute of frauds. Tips for making good business agreements or contracts. Ito mga tips na to. Number 1, get it in writing. Yan, para sa mga kababayan natin ito. Keep it simple. Ika-3, deal with the right person. Okay. Number 4, identify each party correctly, kung ano nationality niya, details, etc. Ano yung kanyang legal capacity. Number 5, spell out all the details. Wag mong isipin na, hindi, alam niya na yun. Hindi ganon. Hindi ka na makipag-kontrata. Number 6, specify payment obligations. Number 7, agree on circumstances that terminate the contract. Number 8, agree on a way to resolve disputes. Number 9, pick a state law to govern the contract. Sa Amerika, pwede to, pero sa atin, isa lang. Diba? Pero in case of conflict of laws, yung sinasabi niya. And number 10, the confidentiality clause. Ayan na mga kapatid, may tips pa ako sa inyo for good business agreements. Okay, so ano naman ang preterition? Preterition, ano ito? Preterition, institution of heirs is annulled. Bakit naman kontrata yung pinag-uusapan tapos nagkaroon ng preterition? Basahin na rin natin para sa mga kapatid natin. Civil law naman to. So, Preteration, ito yung institution of heirs is annulled. Meron kang na-annul siya kasi may tinanggal ka na compulsory heirs. Ayan, binabasa ko kanina yung sa succession. Ano naman yung estoppel by deed? Estoppel by deed. It occurs when a party to a deed and his previes are precluded from denying any material fact stated in the said deed as against the other party and his previes. Ano naman yung estoppel by laches? Conduct on the part of the defendant giving rise to a situation of which complainant is made to seek remedy. Delay in asserting complainant's right. Lack of knowledge or notice of defendant's conduct. Ito yung injury or prejudice to the defendant in the event relief accorded to the complainant or the suit is not held barred. Yan yung estoppel by laches. A laches is considered with the effect of delay. Yan. Prescription is statutory o alinsunod sa batas ng prescription. Ang laches naman is concerned with the fact of delay. Kaya wag magpatumpik-tumpik. Otherwise, yung action mo ay baka ma-estoppel by laches ka na. Okay. Okay, ano naman ang trust? Trust is not a condom. Trust is a legal relationship between one person having an equitable relationship in property, and another person owning. The legal title to such property, ano ba to? Mahirap naman. Wala bang mga comma, period? Pangit no. Ulitin natin. Trust is the legal relationship between one person having an equitable relationship in property and another person owning the legal title to such property, the equitable ownership of the former, entitling him to the performance of certain duties and the exercise of certain powers by the latter. Yan yung pakahulugan ng ating Supreme Court sa trust. Okay, magpunta naman tayo sa ating ika-6, number 6 na major topic. Okay? Lease. Okay? Lease. When a third person already knows of the existence and duration of the lease, he is bound by such lease even if it has not been recorded. Yan sinabi ng Supreme Court. So, ang lease, yan. Purchaser of the thing leased can terminate the lease except when the lease is recorded in the Registry of Property, provisions of right to repurchase, fictitious sale, etc. Galing ng sinabi ng Korte Suprema na yun, no? When a third person already knows of the existence and duration of the lease, he is bound by such lease, even if it has not been recorded. Okay, so ayon dito sa usapin tungkol sa lease, pag ang repair would take less than 40 days, lessee must tolerate. Yan yung nangungupahan must tolerate sa batas. If the repair would take more than 40 days, the lessee may ask for reduction of rent or may ask for rescission of the contract of lease. Ayon sa batas natin ng lease, pag minor repairs ang sasagot yung lessee, yung nangungupahan. Pag major repairs ang sasagot nito ay ang lessor. Failure to make urgent repairs ang mangyayari, suspension of rental. Ulitin natin, major repairs, yung lessor, yung nagpapaupa. Ako yon, charot. Minor repairs, yung lessee, yung nangungupahan. So, failure to make urgent repairs, suspension of rental. Lessee cannot assign the lease contract without consent of the lessor. Hindi pala pwedeng gawin ng nangungupahan yun. Unless there is a stipulation to the contrary. Okay. Ano naman sublease? Generally allowed because the lessee remains a party to the contract. Sublease is generally allowed. Pero ako, I won't allow sublease. So even if the sublessee is not part of the original contract of lease, the lessor may still the lessor may still file, so yung may-ari ng yung nagpapaupa, the lessor may still file an action directa against the sublessee for unpaid rentals, and if the sublessee used the property for purposes contrary for its intended use. Okay? The law does not allow, as a general rule, the law does not allow perpetual lease. There must be a period which may either be definite or indefinite. No lease for more than 99 years shall be valid. So on rural lands, all the time pala to, ba? On rural lands, all the time necessary for gathering of the fruits which the whole estate leased may yield in 1 year. So pag rural land, kailangan niya ng lahat ng oras na kailangan niya para tipunin niya yung mga prutas na pwedeng ibunga nung kabuang ari-arian sa loob ng isang taon. Kapag naman urban lands, from year to year ang lease dapat. If rent agreement is yearly, o kaya naman month to month, o kaya naman week to week. Depende sa usapan. Yan ang batas ng lease natin dito sa Pilipinas. Okay, ano naman yung tacita reconduction? Tacita reconduction or the tacit renewal of lease. Lessee continues in possession of the thing leased for 15 days without the acquiescence of the lessor. Notwithstanding the expiration of the contract of lease, it is understood that there is an implied new lease, not for the period of the original contract, but for the time established by the provisions of the Civil Code. Ito yung kung papayag si lessor. So ito yung nandoon ka pa sa bahay mo, doon sa inuupahan mong bahay, 15 days with the acquiescence, pumayag yung lessor. Kahit na nag-expire na yung kontrata nyo, it is deemed na na-renew siya. Merong new lease. Pero hindi kagaya nung original na lease ninyo, but for the time is established by the provisions of Civil Code. Kung despite notice nagstay pa si lessee, okay, pinapaalis ka na tapos na yung kontrata niya, nagstay pa siya, yung possession niya nagiging in bad faith kasi wala nang acquiescence si lessor, hindi na pumayag si lessor. Magiging ang remedy ngayon ng isang lessor o nagpapaupa is to file an unlawful detainer case. The statute of frauds applies only to contracts that was not performed. So, partial performance doctrine na siya. Yun yung statute of frauds, naalala ko lang na sabihin. Applies only to contracts that was not performed. Okay. Okay, so yun tacita reconduction na nahaluan ko ng statute of frauds sa dulo. Ganda naman itong mga laman nito pero napakahirap basahin. Okay, magtungo naman tayo sa partnership. Okay, partnership. Okay. Ikapito or seventh major na usapin natin regarding civil law is partnership. Partnership is a contract whereby two or more persons bind themselves to contribute money, property, or industry to a common fund with the intention of dividing profits among themselves. So pag sinabi mong dividing profits among themselves, this is onerous. Each of the parties aspires to procure for himself a benefit. Nagsama-sama tayo para lahat tayo, ang layunin natin, magbenepisyo tayo in our individual capacity. So, contracting parties must have the legal capacity to enter a contract. Yan ang requisite para mag-form ka ng partnership. As to the extent naman of the liability, pag ikaw ay capitalist, money or property, pag ikaw naman ay industrial partner, only your industry, yun ang contribution mo. As to the time of entry, original and incoming. So pagka may incoming partner, kailangan ng unanimous consent ng lahat ng original partners. Okay, so ano naman ang principle of delectus personae? No one can become a partner of the partnership association without the consent of all parties, of all partners. The basis is the mutual trust among partners and is inherent in partnership. So, yun nga yung pag incoming partner, kailangan ng unanimous consent. That is the principle of delectus personae. Delectus personae. Ganda ng basis ng partnership, no? Mutual trust among partners. That is the basis. So pag naman ang partnership is for unlawful purpose, the contract is void ab initio. The profits shall be confiscated in favor of the government. Ano naman ang partnership by estoppel? It is one who by words or conduct directly represents himself to anyone as a partner in an existing partnership or in a non-existing partnership. Indirectly represents himself by consenting to another, representing him as a partner in an existing partnership or in a non-existing partnership. Napakapangit na sulat. Partnership by estoppel, pwede siya kasuhan. Naging partner by estoppel siya kasi hindi siya dininay ng partnership eh. Kaya itong si plaintiff believed that he is a partner. Yan, no? Yun ang partnership by estoppel. Ano naman yung partnership tort? Ito naman yung wherein partner misapplies the use of general fund. So, in the case of a partnership tort, kunwari tatlo kaming partners sa isang business, isang firm, tapos yung isang partner namin misapplies the use of the general fund, the partner is solidarily liable. Pero ako hirap ako sa partnership kasi pag tumakbo yan, tumakas yan, paktay, hirap mo hanapin. Although sabihin mong liable siya, ay mahirap. Okay, magtungo na tayo sa ikawalo or number 8 na major topic ng civil law, yung agency. Agency is about representation. By the contract of agency, one person binds himself to render some service or to do something in representation or on behalf of another with the consent of the person to be represented o yung tinatawag na principal. So, kunwari ako ay magiging agent ni LeBron James, siya yung principal, ako yung agent. Okay, so merong bilateral agency. So it is for compensation. It gives rise to reciprocal rights and obligations. Yun ang bilateral agency. Unilateral naman, if gratuitous, it creates obligations to one party. If gratuitous, sabi niya. So as a general rule, what a man may do, he may do through another. Yan ha. What a man may do, he may do through another. So kung ikaw, pwede mong i-kiss yung girlfriend mo, pwede mo rin siyang ipakiss through me. Charot. Illegal yan. Wag. Exception, yung criminal liability. So, that is the exception to the general rule. Hindi pwedeng, yung agent ko na lang yung makukulong kahit ako pumatay kasi agent ko siya. Hindi pwedeng ganun. As a general rule, there is no formal requisite in being an agent except when the law provides a formal requisite. So, an example, ayan ha, agency on the sale of a land should be in writing. So, kung ahente ka sa pagbibenta ng lupa, it should be in writing. It should be in writing. Theory of imputed knowledge. Ano ito? Mahalaga to. Theory of imputed knowledge. That the agent is an extension of the principal. The importance of the duty to give information of material facts becomes readily apparent when it is borne in mind that knowledge of the agent is imputed to the principal. So that is the theory of imputed knowledge. Mabalik tayo sa agency. Although agency pa rin naman to, pero as a general rule, the agent is bound to perform upon his acceptance. An exception, when the execution thereof would cause damage to the principal. That is the exception to the general rule, that the agent is bound to perform upon his acceptance. So, yun yung theory of imputed knowledge. Ano naman yung doctrine of apparent authority? Doctrine of apparent authority provides that even if no actual authority has been conferred on an agent, his or her acts, as long as they are within his or her apparent scope of authority, bind the principal. Okay, special power of attorney. Basahin natin. Special power of attorney limitations. So, excludes the, a special power to sell, yan, ulitin natin, a special power to sell that does not include the power to mortgage. Yan yung mga limitasyon ng SPA. A special power to mortgage that does not include the power to sell. A special power to compromise that does not necessarily authorize submission to arbitration. So, yun yung mga limitations ng special power of attorney. As a general rule, the principal is liable for the expenses incurred by the agent. Exceptions: number 1, agent acted in contravention to the instruction of the principal. This is sumunod. Number 2, fault of the agent. Number 3, if stipulated that the expenses will be borne of the agent, napagkasunduan, si agent ang gagasa sa sarili niya. And number 4, agent incurred the expenses with knowledge of an unfavorable result if principal is not aware. So as a general rule, principal is liable for the expenses incurred by the agent. Exceptions, yung mga nabanggit natin. As a general rule, agency is revocable at will by the principal. Anytime na gustuhin niyang i-revoke yan, pwede. An exception is yung irrevocable agency. Irrevocable agency is coupled with interest if a bilateral contract depends upon it. If it is the means of fulfilling an obligation already contracted. Yun ang exception. As a general rule, agency is revocable at will by the principal. Anytime yan. Exception is the irrevocable agency. Ito yung agency na coupled with interest if a bilateral contract depends upon it. An exception to the exception kapag ka ginamit itong irrevocable agency to defraud the principal. Agency is impliedly revoked when the principal appointed a new agent unless his intention is for both agents to manage his business. An agent who agreed to accept a guaranteed commission is liable. Ayan, liable siya to collect the payments kasi he agreed to accept a guaranteed commission. So, yan yung ating law on agency. Okay. Ayan, nagtapos tayo sa agency. Pero bago natin tapusin yung video na to sa credit transactions, yun yung ating 9th major topic. Mabalik tayo sandali sa contracts. Ito yung reformation of instruments, no? Chapter 4 ito ng New Civil Code. So, reformation of instruments, mga kontrata to. Balik tayo sa contract. So, under Article 1359, reformation, ang reformation is that remedy by means of which a written instrument is amended or rectified so as to express or conform to the real agreement or intention of the parties when by reason of mistake, fraud, inequitable conduct, or accident, the instrument fails to express such agreement or intention. So, ang reformation is a court process. Okay? Pag unwilling, pag willing, at meron din kasing tinatawag na extrajudicial reformation. So, magtungo tayo sandali sa chapter 5, yung interpretation of contracts, no? Although may nabasa na tayo about this kanina. Under Article 1370, if the terms of a contract are clear and leave no doubt upon the intention of the contracting parties, the literal meaning of its stipulations shall control. If the words appear to be contrary to the evident intention of the parties, the latter shall prevail over the former. Okay, under Article 1382, yung mga rescissible contracts is one that was entered into legally by the contracting parties but has resulted in economic damage to one of the parties or an outside party. The court can therefore rescind or set aside the contract for equitable reasons. So to rescind the contract for fraud of creditors, number one, the credit must exist prior to the contract's creation. Number two, there must be an element of fraud or at least the intent to commit fraud to the creditor seeking rescission. Number three, the creditors cannot legally collect their credit. And number four, the object in dispute cannot be in the hands of a third party who hasn't acted in bad faith. So yun yung apat na pwede mong gamiting dahilan to rescind the contract for fraud of creditors. Defective contracts. So, defective contracts, number one, voidable and annullable contracts. Number two, unenforceable contracts. And number three, void or inexistent contracts. So, pag sinabi mo siguro na unenforceable, hindi siya defective kasi unenforceable siya. Anyway, ang voidable and annullable contracts, ito yung mga kontrata that can be ratified. It can be cured by prescription. So, if one party was incapable of giving consent, or if consent was granted by mistake, threat, violence, fraud, or undue influence. Pero, pwede siyang i-ratify. It can be cured by prescription. Sinabi mong unenforceable contract, this is a contract that cannot be accepted as legal in a court of law because of a condition that is not legal. Unenforceable contracts, hindi siya legal eh. Okay, yung nilalaman ng kontrata mo, hindi legal. And number three, yung void or inexistent contracts, ito yung mga walang legal effect. No legal effect. They don't legally exist. It cannot be ratified. It cannot be cured by prescription. So, ang unenforceable contracts, gagamit tayo ng bastos na ano. Kunwari, you should deliver me your body. Unenforceable yun kasi laban sa batas yun eh. Batas on prostitution, for example. Lalo na kung minor yung ginanon mo sa kontrata. Bawal yun eh. So, it is unenforceable. Ang void or inexistent naman is you bring me the moon. Literal. So, paano mo ibibring eh? Diba? Yung mga ganyan. Okay, magtungo naman tayo sa Article 1431 of the Civil Code. Yung estoppel. Lagi natin naririnig yung estoppel. Estoppel is a bar. Estoppel is a bar which precludes a person from denying or asserting anything to the contrary of which has, in contemplation of law, been established as the truth, either by the acts of judicial or legislative officers or by his own deed or representation, either expressed or implied. It concludes the truth in order to prevent fraud and falsehood and imposes silence on a party only when in conscience and honesty he should not be allowed to speak. Ang estoppel is different from a waiver kasi ang waiver is voluntary and intentional abandonment or relinquishment of a known right. Estoppel is different from ratification because in ratification, party is bound because he intended to be bound. Estoppel is different from fraud kasi estoppel exists with or without a contract. Fraud presupposes an attempt to enter into a valid contract or agreement. While estoppel may be raised as a defense, fraud may properly be a cause of action on account of the vitiated consent that it produces. Ano naman ang admissions? Ang kaibahan niya, admissions, a party may be estopped to insist upon a claim, assert an objection, or take a position which is inconsistent with an admission which he had previously made and in reliance upon which the other party has changed his position. So as to silence or inaction naman, estoppel by standing by or laches, ito yung is left on your rights eh. Mere silence will not work an estoppel. Mere silence will not work an estoppel. There must be some element of turpitude or negligence connected with the silence by which another is misled to his injury. So yun ang estoppel. It is a bar. Hindi harang siya. It is a bar which precludes a person, okay, from denying or asserting anything. Wala ka nang pwedeng i-deny o i-assert. Kasi dahil sa iyong sariling kagagawan, hindi ka na dapat payagang magsalita pa. Parang gano'n. O mag-claim pa. Ano naman ang estoppel in pais? This principle applies wherein one, by his acts, representations or admissions, or by his own silence when he ought to speak out, dapat ka magsalita, hindi ka nagsalita, intentionally or through culpable negligence, induces another to believe certain facts to exist, and such other rightfully relies and acts on such belief, so that he will be prejudiced if the former is permitted to deny existence of such facts. That is estoppel in pais. Nagtapos na tayo sa agency, nabalik tayo ng konti sa contract. Pinag-usapan natin yung reformation, interpretation, estoppel. Ngayon magtutungo naman na tayo sa last topic natin sa video lang na ito. Number 9, credit transactions. Okay, ika-siyam na topic natin, major topic, credit transactions. Under credit transactions, nandiyan yung loan, deposit, guarantee, and suretyship, and quasi-contract. So, unahin na natin yung loan. Contract of loan din yan, kung tawagin, di ba? Loan is perfected when the object of the contract is delivered. So, magbasa muna tayo ng mga ibang tungkol sa loan. No? Like for example, the legal interest. No? Pinasa ko to, naisingit siya dun sa persons and family dun sa una. Legal interest rate is 6%. It is applicable only in loans and forbearance of money, goods, or credits, and in judgments when there is no stipulation on the applicable interest rate. It does not apply to judgments that has become final and executory before the effectivity of the circular on July 1, 2013. When there is a law that states a different interest rate, dun lang hindi masusunod itong 6% interest rate. Pero in absence of a stipulation and in absence of a law providing a different interest rate, the legal interest rate as of this moment is 6%. Okay, so when legal interest rate applies, it applies when parties agree that the loan shall be the subject of interest but fail to specify. Oh, may interest yan but they fail to specify. And number 2, parties entered into a verbal contract of loan and debtor incurs in delay. And number 3, there is definite term of interest but failed to indicate beyond. Ayan. So interest rate, mayroong isang interest rate case, sabi ng Supreme Court, it is violative of the principle of mutuality. The debtor participation was reduced to take it or leave it. So sabi ng Supreme Court, it is null and void for being violative of the principle of mutuality, which is essential in contracts. Ang loan is a contract. So take it or leave it, that is null and void. Di pwedeng ganun. Sabi rin ng Supreme Court natin, no interest kapag hindi nakasaad in writing or hindi expressed in a stipulation. So, kailangan kung may usapan kayo ng interest, kailangan naka-express siya doon. Or at least man lang in-express mo na nagkasundo kayo na magbabayad ng interest. Hindi nyo man naisulat kung magkano, at least the legal interest rate applies. Okay, under the topic of loan, meron dalawang uri ng loan. Comodatum and mutuum. Dati hirap na hirap ako intindihin ito, pero yung comodatum, sa comodatum naiisip ko lagi yung nagpaparenta ka ng jet ski. Parang ganon. Although hindi, pero parang ganon. Kasi comodatum, a gratuitous loan of movable property to be used and returned by the owner. Yun ang sabi niya eh. It is a gratuitous loan of movable property to be used and returned by the borrower. Okay? So, it is a loan for use. No transfer of ownership to the bailee. One who has juridical possession. The object is non-consumable Tapos isusoli niya yung very same thing borrowed. So it is a gratuitous loan of movable property to be used and returned by the borrower. Parang ang jet ski, nagparenta ng jet ski. Parang ganun ang naiisip ko. Although ibang rent, pero loan. Ni-loan mo yung isang movable property or car. 'Di ba? Kunwari nag-arkila ka ng kotse, gagamitin ko for 3 days. Sasoli mo rin sa kanya yung kotse. 'Di ba? Parang ganon. Ulitin natin, it is a gratuitous loan of movable property to be used and returned by the borrower. 'Di ba? Nagbayad ka para rentahan mo yung kotse. Parang ganon, rent a car. Parang ganyan. Ang mutuum naman is parang it's the simple loan na sinasabi nila pag tinawag na mutuum. Ownership passes to the borrower. So kunwari ang naisip ko rito na madaling intindihin, car loan. Okay, naguhulugan ako ng kotse. So every month naguhulog ako sa bangko sa kotse. Ownership of the car passes to me. 'Di ba? Hindi ko siya isasaoli hanggang sa matapos ko yung hulugan ko, car loan. The ownership passes to the borrower or motorcycle loan. Yan yung pinaka-common ngayon na mas madali kong maintindihan. In mutuum or simple loan, it is for consumption. Ownership is transferred to Bailey or the borrower. Lender must be the owner because he transfers ownership. Money or consumable only an equivalent of the sum or thing borrowed. For consumption, so money. Pwede siguro, no? Simple loan, nakakalito minsan, no? Pero simple loan, ano ba simple loan? Sabi niya, money or consumable only. Sabi niya, so mali yung example ko ng car loan. Kasi money or consumable only. Pwede, money sa bangko. Tama. Nagpapaloan yung bangko, car loan. So yung ownership of the money is transferred to me. Ayun. So nagets na natin. So yun yung mutuum siya comodatum. Yung comodatum naman is for the use. Pero para kang nagpapaarkila ng jet ski pero hindi ganon. It's for the use. The object is non-consumable, sabi niya. Medyo magulo, no? Ito, dahil nalilito ako, naghanap ako sa Google para mas klaro. Medyo tama rin naman ako. Sabi niya, comodatum loan is a contractual relationship frequently used in the healthcare environment. Such is the case, for instance, with refrigerators or other equipment, non-consumable yan, that pharmaceutical companies lend to hospitals in order to store medicinal products that are administered in clinical trials in which they participate. So that is comodatum. Okay, pinahirapan ko pa yung mutuum. Simple loan lang ito. Ito yung isang example na yung teacher nag-loan siya sa isang financing company with the promise na magbabayad siya ng interest. So that is mutuum or simple loan. Hindi yung car loan kasi ang mutuum nga is money or consumable Hindi mo consumable yung car. So pera yung object dito or any fungible thing. Sabi. So the owner of the pera na hihiramin ng teacher should be yung loan shark. Kasi itatransfer niya ownership ng pera na yun sa teacher. Okay, in its yung mismong pera, yung alangan na may pautang mo hindi mo pera. 'Di ba? So yun ay ibig sabihin. And ang kapalit nun, the teacher would pay yung utang niyang 10 pesos with interest of maybe 2 pesos. Yung mga ganun. That is the contract of mutuum. Simple loan. Simple, pero dahil mutuum siya at saka yung mga definition niya, medyo nahirapan akong unawain. Pero hopefully naunawaan nyo rin, mga kapatid. So, comodatum, ulitin natin para fresh. Comodatum, for use. It is a loan for use. Kunwari ang hospital, ni-loan niya, babayaran niya yung storage na pag-aari ng pharmaceutical companies. Ayan, magbabayad siya sa pharmaceutical companies for the use of those storage. Hindi nagbabago yung ownership. Pharmaceutical company may-ari nun, hindi yung hospital kung saan niya ini-store yung kanyang mga gamot. So that is comodatum. And simple loan, hindi pwede yung ang tawag dito, money or consumable lang. So kunwari, yun nga, pera ang pinakamaganda. O kaya ice cream. May dala-dala akong ice cream. Hindi siya contract for sale. Akin na yung ice cream mo, babayaran ko na lang yung sa ganito with ano. So that is mutuum, pwede yun, it's a fungible thing. Kailangan akin yung ice cream para may transfer ko yung ownership sa kanya. Inubos nyo na, o babayaran nyo na. Pero parang contract of sale, no? Parang, bilhin mo yung ice cream ko. Mas maganda example ng teacher na nag-loan siya sa isang loan shark. Simple loan. Okay, dahil sa nalito ako, instead na basahin ko, pinilit kong intindihin. Okay, sabi nga sa loan, there can be a verbal loan. Ayan, the contention that there should have been a promissory note or written acknowledgement, sabi. The Supreme Court enunciated that this is realistic in business dealings, but it is natural for relatives and friends to not execute a promissory note. Ayan, ganda na sinabi yan, ha? Ganda na sinabi ng Supreme Court na yan, ha? The contention that there should have been a promissory note or written acknowledgement is not realistic kapag between it is unrealistic if the dealings is between the relatives and the friends. The use of credit card is a mere offer to enter into loan agreements. Okay? The use of credit card is a mere offer to enter into loan agreements. Each credit card transaction is considered a separate offer and acceptance, ayon sa Supreme Court. So, bawat credit card transaction is considered a separate offer and acceptance. Only when the credit card company approves the cardholder's purchase, request that a creditor-debtor relationship arises. So, pag inaprubahan nila yung the cardholder's purchase request, doon pala nagkakaroon ng creditor-debtor relationship. Okay. Ano to? Interest may be simple, compound, and legal interest. Interesting din sinabi ng Korte Suprema na yun. The use of credit card is a mere offer lamang. Diba? Only when the credit card company approves the cardholder's purchase request that a creditor-debtor relationship arises. Yan, ayon yan mismo sa ating Korte Suprema. Alright, credit transaction pa rin ang topic natin. So, natapos na natin loan. Dito naman tayo sa deposit. Under 1962 and 2009 of the Civil Code, no? Okay, credit. Ang subject ng isang deposit ay only movable things. Okay? Maybe orally or in writing, yun ang sabi rito. Under Article 1962, deposit is constituted from the moment a person receives a thing belonging to another with the obligation of safely keeping it and of returning the same. Yun siya. Deposit, saan to? Is a real contract just like comodatum and mutuum which is perfected upon delivery of the thing. So ulitin natin para mas klaro. Under Article 1962 of the Civil Code, deposit is constituted from the moment a person receives a thing belonging to another with the obligation of safely keeping it and of returning the same. If the safekeeping of the thing delivered is not the principal purpose of the contract, there is no deposit but some other contract. So, merong dalawang uri ng deposit, judicial deposit and extrajudicial deposit. So, yung judicial deposit, will yan of the court. Pinahintulutan ng korte. It is security to ensure the right of a party security to ensure the right of a party to property or to recover in case of favorable judgment. It involves movables or removables pagka judicial deposit. It is always onerous and it is upon order of the court when litigation ended. Ang extrajudicial deposit, it depends on the will of the parties or contract. It is for custody and safekeeping. It involves movables only and may be compensated or not kasi generally naman gratuitous ang extrajudicial deposit rather than yung judicial deposit which is always onerous. Basahin nga natin ng konti ito. Mercantile insurance obliged itself to pay DLCI immediately upon demand. Thus, it stands as a contract of surety contemplated under Article 2047 of Civil Code. While the contract of surety stands secondary to the principal obligation, the surety's liability is direct, primary, and absolute. This liability attaches the moment a demand for payment is made by the creditor. So medyo naisingit natin doon yung contract of surety, no? Kasi nakasulat siya sa ilalim nitong deposit. Pero at least, ang ganda nung sinabi niya, no? When the principal intention is not safekeeping, then it is some other contract, hindi siya deposit. Isang bahagi rin ng credit transactions, yung quasi-contracts, no? When they arise, ito nabasa na natin kanina, ito basahin lang natin ulit for purposes of mas sama-sama yung magkakasama. When they arise from lawful, voluntary, and unilateral acts which are enforceable to the end that no one shall be unjustly enriched or benefited at the expense of another. Again, yung example nito, the obligation to return money paid by mistake or which is not due. Okay, yung binasa natin case, nakakabasa lang natin yung mercantile insurance obliged itself to pay DLIC. Tapos sinabi ng Korte Suprema na it is a contract of suretyship. Yan. This will, anong tawag dito? Segue siya. Papunta sa isa nating topic under credit transactions, yung suretyship. The legal definition of suretyship is the contractual relationship in which a surety engages to answer for the debt or default of a principal to a third party. Kaya basahin natin ulit yung case. Deposit, binabasa natin kanina, tapos may bigla tayong binasang case, no? Mercantile insurance obliges itself to pay DLCI immediately upon demand. Thus, it stands as a contract of surety contemplated under Article 2047 of the Civil Code. Kasi, inobliga mo yung sarili mo to pay a third person upon demand. While the contract of surety stands secondary to the principal obligation, sabi ng Korte Suprema, the surety's liability is direct, primary, and absolute. This liability attaches to the moment a demand for payment is made by the creditor. So yun, naitawid natin yung suretyship. Napakaganda ng sinabi ng Korte Suprema when it comes to surety and guarantor. Ako bilang isang ordinaryong tao, hindi man ako abogado, nalilito ako. Pero ang sabi ng Korte Suprema, a surety is an insurer of the debt, whereas a guarantor is an insurer of the solvency of the debtor. A suretyship is an undertaking that the debt shall be paid. A guarantee is an undertaking that the debtor shall pay. Ganda, no? Stated differently, a surety promised to pay the principal's debt if the principal will not pay, while a guarantor agrees that the creditor, after proceeding against the principal, may proceed against the guarantor if the principal is unable to pay. Ganda, no? A surety binds himself to perform if the principal does not, without regard to his ability to do so. A guarantor, on the other hand, does not contract that the principal will pay, but simply that he is able to do so. In other words, a surety undertakes directly for the payment and is responsible at once if the principal debtor makes default, while a guarantor contracts to pay if by use of due diligence, the debt cannot be made out of the principal debtor. Ang ganda ng paliwanag niya sa kaibahan ng suretyship and guarantee and suretyship. Galing talaga ng Korte Suprema. Okay, magtungo naman tayo sa topic natin. Last topic ito for part 1, no? pinart 1 ko tong napakaraming topics ng preliminary title, persons and family relations, succession, obligations and contracts, sale, lease, partnership, agency, credit transactions. Ito mga dinidiscuss natin in torts and damages. Yan yung parang pinaka part 1 ko ng civil law, no? So, torts and damages yung number 10 doon sa ating part 1. Ito yung last topic ng part 1. So, if the cause of action is based on maritime tort, the provisions of the Code of Commerce are applicable pag maritime tort. An action based on quasi-delict resulting from maritime collision is not specifically regulated by the Civil Code but by the Code of Commerce. Thus, if the cause of action is based on quasi-delict and not contract, the rules provided by the Code of Commerce applies. Yun ang sinabi ng Korte Suprema sa Allison Shipping Lines versus CGU International Chorva. So, quasi-delict or tort under Article 2176 of the Civil Code, whenever by act or omission causes damage to another, there being fault or negligence, is obliged to pay for the damage done. Such fault or negligence, if there is no pre-existing contractual relation between the parties, is called quasi-delict or tort. So, under Article 19, it is the catch-all provision kasi itong Article 19. Sabi niya, honesta vivere alterium non lascedere suneria quique tribure. Actually, hindi ko na mabasa ang labo. Sabi niya rito, hindi ka pwede magkaso pag yan lang, guide lang siya ng Code of Conduct, yung Article 19. Hindi siya cause of action. Na it is always paired, itong catch-all phrase ng Article 19, it is a catch-all phrase na it is always paired with another article like yung Article 20 ng Civil Code. Every person who, contrary to law, willfully or negligently causes damage to another shall indemnify the latter for the same. So this article allows recovery for willful and neglectful violations of existing law as basis for injury. Okay. So, ang concurrence of cause of action, yung proscription. It is against double recovery. So, kapag nakatanggap ka na ng medical expenses, hindi ka na pwedeng magsigil pa ulit ng medical expenses ulit. So, yun yung tinatawag na concurrence of causes of action. No? Nakakuha ka na eh. Diba? Nakakuha ka na ng medical expenses, manghihingi ka pa. Nanguha ka dun sa nanay nung nakasakit, tapos kukuha ka pa ulit doon sa tatay niya naman. Mali naman yun. Okay, so sa usapin ng tort, ano yung proximate cause? A proximate cause is an act from which an injury results as a natural, direct, uninterrupted consequence and without which the injury would not have occurred. Kung wala yun, hindi mangyayari yung injury na yun. That is the proximate cause. Okay? Ulitin natin, an act from which an injury results as a natural, direct, uninterrupted consequence and without which the injury would not have occurred. Ayon nga sa ating Korte Suprema, to hold the defendant liable for torts, it must be clearly shown that he is the proximate cause of the harm done to the plaintiff. Ito. Yung damnum absque injuria. Sabi ng Korte Suprema rito, a person has a right to the natural use and enjoyment of his own property according to his pleasure for all the purposes to which such property is usually applied. As a general rule, therefore, there is no cause of action for acts done by one person upon his own property in a lawful and proper manner, although such acts incidentally cause damage or an unavoidable loss to another, as such damage or loss is damnum absque injuria. So when the owner of property makes use thereof in the general and ordinary manner in which the property is used, such as fencing or enclosing the same as in the case, nobody can complain of having been injured because the inconvenience arising from said use can be considered as a mere consequence of community life. Ganda ng sinabi ng Korte Suprema. The proper exercise of a lawful right cannot constitute a legal wrong for which an action will lie, although the act may result in damage to another, for no legal right has been invaded. One may use any lawful means to accomplish a lawful purpose, and though the means adopted may cause damage to another, no cause of action arises in the latter's favor. An injury or damage occasioned thereby is damnum absque injuria. The courts can give no redress for hardship to an individual resulting from action reasonably calculated to achieve a lawful means. So yun po ang damnum absque injuria. Okay, ito naman yung vicarious liability. Vicarious liability. So, ito ang binabasa ko isang case sa jurisprudence. Sabi ng Korte Suprema, under Article 2180 of the Civil Code, provides that a person is not only liable for one's own quasi-delictual acts, but also for those persons for whom one is responsible for. This liability is popularly known as vicarious or imputed liability. So to sustain claims against employers for the acts of their employees, the following requisites must be established. Number 1, that the employee was chosen by the employer personally or through another. Number 2, that the service to be rendered in accordance with orders which the employer has the authority to give at all times. And number 3, that the illicit act of the employee was on the occasion or by reason of the functions entrusted to him. So yun po ang vicarious liability under the Article 2180 na ipinaliwanag ng ating Korte Suprema. Okay, and finally, what are the kinds of damages? Okay. Number 1, actual or compensatory damages. The purpose is simply make good or replace the loss caused by the wrong. Manner of determination, ayon sa jurisprudence, the claimant must produce competent proof or the best evidence obtainable, such as receipts to justify an award therefor. Actual or compensatory damages cannot be presumed but must be proved with reasonable certainty. Ikalawa, anong tawag dito? Ayan, actual or compensatory damages. Meron ding special or ordinary damages. Ito raw yung generally inherent in a breach of a typical contract. So, generally inherent siya itong special or ordinary damages sa breach ng contract. Moral damages naman, the purpose of this is to enable the injured party to obtain means, diversion, or amusement that will alleviate the moral suffering he has undergone by reason of defendant's culpable action. No proof of pecuniary loss is necessary. The assessment is left to the discretion of the court according to the circumstances of each case. However, there must be proof that the defendant caused physical suffering. Yan ang sinasabi. Sa criminal cases naman daw, moral damages may be awarded to the victim in criminal proceedings in such amount as the court deems just. So yun nga, sa criminal cases, yung moral damages, di na raw kailangan ng pleading or proof of basis thereof. Okay, special damages are those which exist because of special circumstances and for which a debtor in good faith can be held liable if he had been previously informed of such circumstances. Meron din namang nominal damages, the purpose of which is to vindicate or recognize the injured party's right to a property that has been violated or invaded. Hindi rin daw kailangan ng proof of pecuniary loss dito. Proof that a legal right has been violated is what is only required. Usually awarded in the absence of proof of actual claims. Temporary damages. When the court is convinced that there has been such a loss, the judge is empowered to calculate moderate damages rather than let the complainant suffer without redress. It may be recovered, itong ang temporate damages, when the court finds that some pecuniary loss has been suffered but its amount cannot from the nature of the case be proved with certainty. No proof of pecuniary loss is necessary. Liquidated damages, ang purpose nito ito yung mga frequently agreed upon by the parties, either by way of penalty or in order to avoid controversy on the amount of damages. Manner of determination nito, if intended as a penalty in obligations with a penal cause, proof of actual damages suffered by the creditor is not necessary in order that the penalty may be demanded. No proof of pecuniary loss is necessary. Exemplary or corrective damages, ito yung intended to serve as a deterrent to serious wrongdoings. Para ma-determine mo yung exemplary damages, number one, the claimant, kailangan mo munang ma-determine that the claimant is entitled to moral, temperate, or compensatory damages. And number two, that the crime was committed with one or more aggravating circumstances, or the quasi-delict was committed with gross negligence, or in contracts and quasi-contracts, the act must be accompanied by bad faith or done in wanton, fraudulent, oppressive, or malevolent manner. No proof of pecuniary loss is necessary. So, yung dalawang yon para makapag-avail ka ng exemplary or corrective damages. So, review natin ano yung mga binasa nating damages ngayon. Actual or compensatory, moral damages, pangalawa. Pangatlo, nominal damages. Pang-apat, temperate damages. Pang-lima, liquidated damages. And pang-anim, exemplary or corrective damages.